All right, Wendy, do you want to start it?
The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to this ACED's webcast, Amending the Federal Rules of Civil Procedure, again, the Portland meeting presented by Xylab. I'm your host, Robert Holson of ACEDS.org, and in a moment I'm going to introduce our two great experts. But first of all, as always, I have a couple of quick announcements for you. For those of you who aren't familiar with us, we are a members-only association that provides training, resources, and networking to the e-discovery community. We also offer the Certified e-discovery Specialist credential, which is held by hundreds of professionals across the Americas, Europe, and Asia. You can join today and start receiving a number of benefits exclusive to our members, including news content, on-demand web seminars, our Bits and Bytes newsletter, and discounts on certification and our upcoming conference. Speaking of, the 2014 ACEDS conference is just 5 weeks away. We will be meeting this year from April 27th to 29th at the beautiful Westin Diplomat in Hollywood, Florida. The conference features 14 panels, 36 top speakers, and beachside networking events. Among the presenters is Stephen Levy, the former head of legal operations at Microsoft and a pioneer of legal project management, and Judge David Waxy, who has authored several groundbreaking e-discovery decisions. Top litigators, corporate attorneys, and rule makers will also present, along with the two great experts you will hear from in a moment. So you can register or get more information at ediscoveryconference.com, which you see there on your screen. And as a thank you for being here, if you enter the code RULES20, you will receive a 20% off discount to the conference. Again, that's RULES20. As I said, we have two excellent speakers for you today, both of whom will present at our April conference. Tom Allman is an adjunct professor at the University of Cincinnati College of Law who speaks and writes extensively on the interrelationship of corporate compliance policy and the effective management of ESI. Formerly, he served as General Counsel and Chief Compliance Officer of BASF, where he worked from 1993 to 2004. He is also Chair Emeritus and an active member of the Steering Committee of the Sedona Conference Working Group 1 on Electronic Document Retention and Production. Tom will be a panelist on the opening session of the ACEDS conference, which will discuss many of the important looming rules amendments that we'll address today. Tom, thanks a lot for being here.
Thanks, Robbie.
Tom is joined by Mary Mack, Enterprise Technology Counsel at Xylab, who will be presenting on best practices for technology-assisted review and e-discovery taboos at the ACEDS conference. She is among the most highly regarded consultants in the field, and at Xylab advises counsel and IT on how to implement software to drive down the corporate costs associated with e-discovery and big data. Formerly corporate technology counsel for FIOS, she is a leading consultant on cases that deal with non-standard data like social media, Office 365, and audio, and advises companies on how to develop and deploy defensible information and e-discovery policies. Mary, thanks for joining us.
Oh, thank you, Robbie.
All right, so before we begin, I want to remind our audience that if you have questions, you should type them into the chat box you see on the right of your screen, and Mary will field them at the end of the presentation. Okay, again, Tom and Mary, thank you again for being here. I'll hand it off to both of you.
Thanks, Robbie. We got quite an agenda today, and we're very, very happy to have Tom Allman here. There's all sorts of things happening with the rules. The agenda book for the upcoming meeting in April came out on Friday, and Tom has been combing through it with a fine tooth comb. And we've got some very, very fresh information for you on this webcast. And without further ado, Tom, I'd like you to take it. We can see the agenda on the screen here. How did we get here, and what is in this package?
Okay. Well, let me, if you don't mind, Mary, let me have that previous screen. I'll just run through the general topics and then move to the actual amended package itself. Let me just first say that I'd like to emphasize what Mary just alluded to about the recent events. When we first planned for this seminar, what I had anticipated I would be doing would be describing to you how what we call the 2013 package of amendments were put together over a period that really began back in 2010. And then I was going to describe the pluses and minuses that were articulated at the recent series of hearings, public hearings, and then I was going to explain how we were all looking forward to joining Mary in Portland, Oregon in early April to discuss them further.
Yeah, like they would be ratified as is.
Yes, we all expected there to be no changes. So what changed was on this past Friday, the two subcommittees, which I'm going to describe in a minute, the two subcommittees decided they were going to do 180s on a couple of things, and in one particular case, Rule 37E, they decided to rewrite the rule in its entirety. So that's what's changed, and it's only 3 days old, so what you're going to hear from me today, at least, is my first reactions and my first thoughts on this. By the time of the ACES conference in 5 weeks or whatever it is, we will be joined by a member of the Rules Committee who was deeply involved in these changes, and we're going to have a much more firm idea at that time, having already seen what happens in Portland, Oregon. But so, for better or for worse, you, the audience, are participants now in probably the first discussion of a public nature about these proposals. So what I want to point out on this slide before we get into the details is that the two key elements, proportionality and preservation, not only were the two key elements that were highlighted in the original package discussions, but they have now been changed. And so we're going to devote a considerable amount of time today for them. So Mary, if you could, let's go to that next slide. Here is the lineup of the package that I thought we were going to be discussing. And what I have done here is run a line through one of the important elements of the package, and that is among the things that the committee had decided to do was to reduce the number of presumptive limits on depositions and interrogatories, both oral and written depositions, as well as the duration of oral depositions. The subcommittee, after considering what they heard at the public comment period, has decided to strike that. So that's why there's a line through there. And just to give you a feel for what's going to happen at Portland, on April 10th and 11th, the Rules Committee will meet as a committee of the whole, in other words, the entire Rules Committee, and they will consider the recommendations as now modified by their two subcommittees, which I'll explain in more detail in a minute. But they don't have to adopt it. So this line through presumptive limits might be withdrawn if, in their wisdom, they choose not to go along with the recommendation. Now, my personal prediction is that they will, in fact, adopt that, and we'll get into that in more details later. But the other three things that I've highlighted are the proportionality scope of discovery changes and the sanctions and the preservation guidance. And those are the ones we're going to spend most time on today. So if we could have the next slide, Mary. Now, how did we get here? Back in 2006, you may remember, there was a considerable number of changes that were made to reflect the fact that electronically stored information had suddenly become the norm rather than simply an outlier. And you'll remember that we first defined what it was in the rules. We then said basically what were the form or forms in which it should be produced. But more importantly, we tried to see in the rules a methodology for early discussion of preservation, form of production, and privilege issues. And we also made an allusion, although the words were not inserted at the time, we also made an allusion to the use of scheduling orders as a way of embodying agreements on this matter. Between that time and now, another feature of the 2006 amendments, the Rule 37E, so-called safe harbor provision, did not take on the life that many of us had hoped it would take, and in the views of many, it was ineffectual. So by the time of the Duke Conference in 2010, the folks who attended that conference were told by a panel on which I sat, along with Judge Shinlin and Judge Fasciola and three other members, one of whom was now on the Rules Committee. They were the panelists. We told the committee and the folks in attendance at the Duke Conference in 2010 that it was time to write a preservation rule. and that only a preservation rule would lay the appropriate groundwork for people to pull back from what we were beginning to see and has now been labeled as over-preservation. In other words, the reaction to a fear of the unknown that causes one to spend an inordinate amount of money to preserve just about everything. Between 2010 and today, the Rules Committee took the kinds of things they heard about at the Duke conference and divided them into two packages. One is called the responsibility of the Discovery Subcommittee, and that was primarily preservation and sanctions. And that subcommittee is chaired by Judge Grimm, who at the time was a magistrate judge and is now a district judge. And they have devoted themselves primarily to what has become Rule 37E. The second subcommittee is the Duke subcommittee, and that committee was charged with the responsibility of everything else. So when you saw that list a minute ago, everything on that list except for Rule 37E and preservation guidance was the responsibility of the Discovery Subcommittee, and I'm sorry, the Duke Subcommittee, and that subcommittee has been chaired by Judge Kodal. Judge Kodal is a practitioner, is a judge in the Southern District of New York, and he was also in charge of and organized the Duke Conference, so he was extremely well equipped to continue this task. They met, these two subcommittees met repeatedly, and the Rules Committee reviewed their work, and they held two mini-conferences, one on preservation and one on the so-called Duke amendments. And in August of 2013, just this past summer, they released for public comment this entire package, which I put up on the screen a minute ago. And again, as I mentioned at the introduction, last Friday, they further announced after public comment that they had some further suggestions, and that's what we're going to take up at Portland. So if we could see the next slide, Mary. That's where we are today. The subcommittee has changed their mind on a couple of places. There were over 2,300 written comments, and I'm not talking about just little paragraphs. I'm talking about comments that range from 1 or 2 pages to 40 or 50 pages. There were 3 public hearings. One was held in Dallas. That was the most recent one. And then earlier ones in Washington and Phoenix were held. And these were places where over 120 people testified. They received questions from the Rules Committee, and they were long, exhausting hearings, and very, very well done. I had the pleasure of attending or listening to each of them and was very impressed. The final revisions in the agenda book came out on Friday, as I said, and on April 10th and 11th in committee, we'll be faced with the 3 choices I put there. One, they can adopt the recommended changes, they can revise the recommended changes, or they can order republication. In other words, a second go-round of public comments, oral and written, on these proposed changes. Now, I will tell you that this morning, I spent the morning reading the 8 subcommittee meeting minutes, and I found in those minutes that at least one of the subcommittees believes that they do not need to republish these for public comments. It's too early to predict how the full Rules Committee will treat the matter, but I will say this, that back in the 2005-2006 cycle, the first draft of the Rule 37E that was put out for a safe harbor comment was changed dramatically during the meeting, and they did not republish it, and they just went ahead and adopted it as changed by their subcommittee. So it remains to be seen whether what we're going to be talking about here is the final product or whether it will be further changed by the Rules Committee. Okay, Mary, the next one. And Mary, I didn't mean to foreclose any questions you might have as we go forward, or anybody in the audience.
That's true. We'll be taking questions, you know, as they come, if they're part of the discussion where we are. And one thing I just want to make a note is that the agenda book that Tom is talking about reading this morning is 580 pages, and at the end we'll have a paper which is Tom's analysis of that and where we're going from here. That is down to what, about 40 pages, Tom? So it's quite a.
It is. It's only 40 pages long, and most importantly, the last 5 pages are the text of the changed proposed rules. So that in one place you get all the rules.
Right. Yeah. So don't worry about having to wade through that 580 pages.
I should add that for those of you who are interested in this, just go to uscourts.gov, then look for the section that talks about rules and practices of the rules of procedure, and then you'll be able to drill down pretty easily to the archives and records of the committees. Pick the committee that's in charge here, which is the Rules Committee, and you will find a copy of the agenda book, which is there in PDF, and you can easily download it and then go through and print out whatever you want to read.
That's true, and we'll include a link to that because it is it's kind of buried in there. So,
but it is there, and you can get
Yep.
there. I promise
Yep.
you.
Yes, you can.
Okay, so it's wise to keep in mind where we are. We're really at the very beginning of a fairly deliberative process. Once the Portland meeting concludes on the 11th of April, then the so-called standing committee will have a chance to review their decisions. Now, it's not as though the standing committee is in the dark about what's going on. In fact, the chair of the standing committee, when I read the minutes of the subcommittee meetings today, I noticed that he attended every single one of their meetings. So the chair of the standing committee is very up to speed on what's going on, and I'm sure the standing committee will have members in attendance or listening to the Rules Committee meeting in Portland. So, but nonetheless, the standing committee in May of 2014 does have the right to make decisions. Among them could be ordering republication of Rule 37E if they decide to adopt the recommendations. After the standing committee meets, whatever they decide then goes to the so-called judicial conference, which is made up of the senior chief judges from around the country and all the circuits and others. And then, of course, the Supreme Court gets a chance to weigh in, and if they choose not to adopt them or if they choose to amend them, so be it. We live with that. But after the Supreme Court makes this decision, we then kick into what's called the Rules Enabling Act process, whereby the Congress, which has sort of delegated or co-delegated its power of rulemaking, they then have a period of 6 months in which they can do just about anything they want to the rules. They can nullify them, they can revise them, or they can just sit back and do nothing, and in which case, at the end of that period, they become rules. And the earliest date that would occur would be December the 1st of 2015.
And
so
Tom, do both houses of Congress need to do something, or is it just the particular committee in Congress?
Both.
Both houses?
Yeah.
Okay.
Okay, so now let's turn to the heart of the matter, and I apologize for this long deliberative introduction, but let's go to the first slide, Mary.
Okay, can you see that, John?
Well, Mary, my internet connection is lost, but I happen to have printed out the slide. So. Well,
good. We're on 26B1 then, Tom.
Okay, thank you. Luckily, I have it right in front of me.
We're in the scope first one. Yep.
The single most controversial matter that came before the public hearings was the question of whether or not the concept of proportionality was getting sufficient attention by the courts and by the parties, or whether or not there was excessive discovery costs which needed some kind of remedy. And the comments more or less split down the middle. The plaintiffs' bar basically said, hey, things are going along fine, we don't really need to do anything. And if you do make any change, it's going to provide another one of these kind of stop signs that prevent people from getting the discovery they need. The defense bar said, look, this is an underused tool. It's already required under 26G that attorneys and parties take this into account when they make their discovery requests. There's nothing wrong with emphasizing it. by moving it into the scope of discovery itself. The plaintiff bar came back and said, yeah, you do that, though, you're going to put the burden on us, the plaintiff's bar, the requesting party bar, to say up front that we've looked through this material and it's proportional as well as relevant. And that's not fair, and we should not have that burden placed upon us. So the committee listened to all this. They more or less challenged each of the witnesses to give them examples as to how this would hurt them if it was done. And the bottom line is what you're looking at on the screen. And let me walk you through that. In bold are the changes that were part of the original proposal, and in italics are the revised changes that came out on Friday. So the key change is to say that any discovery has to be both relevant and proportional to the needs of the case. And as you see, it then goes on saying, considering, and then skipping to the italics part, the importance of the issues at stake in the action, the amount of controversy, the parties' relative access to relevant information, and then on with the rest of the factors that were already buried elsewhere in Rule 26. The subcommittee has recommended that instead of the importance of the issues, that instead of the amount in controversy being the first of the factors to be considered, that it should be the second, and that the importance of the issues at stake should be the first. So that's why the striking out and then the inversion. And then they have added a new phrase which says the parties' relative access to relevant information. And that is intended to reflect the complaints that in asymmetric litigation, it's always going to be the case that what appears to be excessive discovery is directed at the party with the most of the information, namely in the employment cases, for example, that would be the employer. And one can debate whether or not that's a smart thing to insert, but it is believed by the subcommittee at least that this responds to the many complaints that they receive from a number of law professors as well as plaintiffs' bar and requesting bar practitioners. So that's that change, Mary. I don't know if you want to comment on that any further.
Well, no, just that there's an and in there, so all the factors are going to be considered. So the inversion doesn't seem to me to be huge, but they did add that additional factor and about the relative access, and so that is different. But Tom, they've also deleted some things that are pretty significant.
Yes,
as well. On the next slide, yeah.
Okay, I was going to say if you could turn to the next slide. Yeah, they've made 3 deletions, and each of these 3 deletions were also controversial, although in slightly different ways. First, the first deletion is to take out the reference to expanding discovery to the subject matter. You know, currently it's relevant to claims or defenses. There was not much opposition to that change, although the professors, the academic professors in particular, didn't like it. They liked having it as broad as possible. The second deletion is the one that the defense bar, the producing party's bar, was most excited about, and that is the statement that relevant information need not be admissible at the trial if the discovery appears reasonably calculated to lead to the discovery of admissible evidence. To many folks, that is shorthand for saying, hey, as long as you can show some plausible connection to something down the road, of course it's discoverable. And that's not what it says, and that's not what it's meant. And so the committee is pretty adamant about wanting to take that sucker out of there. That one, I suspect there will still be a fight at the Rules Committee level over that one, but I think that will also come out. And then finally, there is a section, if you go back and look at Rule 26B1 in today's form, it is actually the longest or second longest rule in the entire federal rules. And one of the reasons it's so long is they give a long laundry list of types of things that are discoverable, and they list documents and locations of parties and so on and so on. And the committee decided, originally decided that everyone understood that these factors, these types of things were discoverable, and there was really no need to clutter up the rule with it. However, during the public comment period, a number of very intelligent comments were made. Well, what if somebody misreads that as implying that you don't have the ability to discover these things? And they particularly cite discovery about discovery. In other words, about information systems and so on. And so the committee has decided to amend the committee note to explain that while they did remove this stuff, it is not intended to indicate that it's a lack of discoverable information, as long as it can be seen to be relevant to the claims or defenses of the parties.
Right, and they said that it was so basically so ingrained that it was cluttering up the rule. This is a provision that is usually used in the early stages around reducing scope or assessing scope of computer information systems. So there were a lot of e-discovery practitioners that were concerned about that, and the comment in the rule shows that the deletion is not to foreclose that discussion.
And I'm sure you noticed, Mary, that in the revised committee note, the subcommittee now recommends that the committee note recite at some length the history of how we got these proportionality factors in the first place, and especially how they are not intended to restrict those the use of discovery in cases where there are non-monetary factors. For example, in civil rights litigation or in injunctive relief against violations of constitutional law and so on, where you can't put a dollar sign on it. Nonetheless, the original 1983 committee notes, when the rule was first enacted, made it very clear that you could still get discovery, and they have re-emphasized that in the revised committee notes.
Exactly, there's quite a discussion on that as an example of a lower paid person versus a higher paid person. What the damages might be and what might be considered proportional in that case. I was very interested to read all the various types of litigation that are considered in shaping these rules. And we had quite a few questions about can our listeners get copies of the slide, or the question is, do I just need to write a lot faster? And you'll definitely get copies of the slides. We'll send you the deck so that you can print them out as you would, and also at the end we'll give you an opportunity to get Tom's paper. There's also been a bunch of questions about that, Tom. So yes, oh, go ahead.
No, go ahead.
I was going to say, shall we turn to the issue of the day, the total rewrite?
Yeah, let's talk first about about what the original. One more comment on what we've just said about proportionality. Nothing that either Mary or I have said is in any way intended to diminish the fervor with which folks who opposed this change articulated their views. And I should point out that there are other ways to achieve this same approach. For example, they could have simply broken the Rule 26b1 statement that we showed you a minute ago into two parts. We could have simply had a sentence that said that discovery is obtainable as long as it's relevant to the party's claim or defense and proportional to the needs of the case, period. There could have been a period after the end of that. And then separately, we could have simply said, as we do now, that a court should limit discovery based upon the importance of the issues, Those kinds of considerations are valid considerations, and it's very much open to debate as to whether or not the subcommittee will be overruled by the full committee. I personally predict they will not be overruled, and that the language that we have shown you will be adopted. If you wish to read the arguments, pro and con, A very good summary of them appears in the minutes of the subcommittee that is in that doggone 580-page agenda book. You have to look at the front, you have to get the index, and then you have to scroll down to the page. But if you want to get into detail and get into the weeds on this, that's the place to go. Now, if you want to get into the weeds about the comments that were made, my paper is the place to go. I have extensively cited to the key comments that were made by the requesting bar and the academics, and by the defense bar. And so this paper that we keep referring to, which is around 40 pages, does have summary of the key comments. But what we haven't told you yet is where do you get the comments if you want to see them yourself. Again, all these links are in my paper, but there is a website that was established that has all 3,200 comments in it, and it's an indexed website. You can plug in the name or even just a clause or a concept, and it does an excellent job of searching all the comments and then lists them in descending priority, just like Google. Oh, actually, Google doesn't do that, does it? Well, anyhow, it's descending relevance. And the place to access that website is, again, through uscourts.gov. And if you haven't ever been to uscourts.gov, it's time for you to go there, because that is the source for all this type of information. Okay, Barry, so let's turn to the original attempt to deal with Rule 37E. Now, in the interest of disclosure, and anybody who knows, I'm sorry, Mary, you were going to say something.
No. I just hit my mic. Sorry.
All right. Well, in the interest of disclosure, I have to confess that I am the one that back in 2001 wrote a law review article advocating a safe harbor rule, and much of the language in the 2006 proposal, it was consistent with what I recommended now, 12, 13 years ago. So I had a lot invested personally in this and was disappointed when it became clear that courts were not applying it the way I thought it ought to be applied, which is to say that any time a party acts in good faith in the managing of their routine information systems, whether or not a duty to preserve has yet attached, they should not be sanctioned. That's not the way the court rulings came out. It seems to be well established, and in reading the subcommittee minutes, they seem to buy the argument that the original rule said that once the duty to preserve attaches, Rule 37E's protections are lost. They're gone. It doesn't matter if you act in good faith. They're gone. So in the period between the Duke Conference and last Friday, we had what you have in front of you as a proposal which was intended to supersede and absorb and otherwise compensate for the limitations of the existing Rule 37E. Now, the first thing to notice about the original proposal is it was not confined to ESI. It is not confined to ESI. It applies to all types of discoverable information. The second thing I want you to know, and you'll see it when Mary gets us to the next page, is that the subcommittee has now changed its mind and has gone back to the idea of making a rule that applies only to ESI. Keep that difference in mind as I go through the objections to this first effort. Under this first effort, in its somewhat awkward terminology, the court would first determine if a party failed to preserve discoverable information of any type that should have been preserved in the anticipation or conduct of litigation. Now, I just said a minute ago, actually more like 10 minutes ago, that when we were on the Duke panel, we, that's Judge Schindler, myself, Judge Fasciola, John Barquette, who's now on the Rules Committee, and two others, we recommended that they come up with a preservation rule that spelled out what the scope of discovery, or scope of preservation was, when it was triggered, and what you had to do as a result. The Rules Committee held a mini-conference and concluded that that couldn't be done. So instead, this first clause about a party failing to preserve discoverable information that should have been preserved simply is a cross-reference to the existing common law duty to preserve. And the committee did not attempt to define what it meant, sort of. You'll see down at the bottom of that slide the word guidance hyphen factors. Well, they threw some factors in, and we'll talk about them in a minute. But then they broke the world into two parts. Part A is additional discovery, curative measures, paying reasonable attorney's fees caused by the failure, etc. Those would be permissible by a court if a party failed to preserve without any particular showing of either culpability or prejudice. The second part of the rule was the sanctions portion, and under that second part of the rule, a party could be sanctioned by use of any of the sanctions listed in another part of Rule 37 or an adverse inference instruction, and they didn't define what kind, but only if the court found that the party's actions were the cause of substantial prejudice in the litigation and were willful or in bad faith. Then, to make things even more confusing, they added another subsection preceded by the word "or," which said that the failure to preserve irreparably deprived a party of any meaningful opportunity to present or defend against claims in the litigation. Now, the reason for the second section, which arguably could swallow the first if the court found that someone was irreparably deprived, was the Silvestri case. And you all remember the Silvestri case, I'm sure. And that's the one where the guy's car was wrecked. He was in the hospital. He wasn't totally in command of what he was doing. The car belonged to his landlady. It was disposed of. And when General Motors eventually got sued, they said, hey, how can we be forced to defend a suit when there's no car? I'm oversimplifying, obviously. So that was a case where there was no proof of culpability or serious culpability on the part of the person that lost the stuff, but the harm from the loss, so the irreparably deprived person, General Motors, was such that the court thought it was unfair to proceed. So it has been argued, in retrospect by the subcommittee that they were trying to do too much in this one rule. And in fact, during the public comment period, those of us who looked at it and testified almost universally suggested that B2 should be dropped. Now, there were some pretty good suggestions on what they should do instead. For example, just simply confine it to tangible property, or redefine 37E to apply to electronic information and documents. But as I said, instead, in the new subcommittee considerations, they have decided to retreat back just to ESI. And as they point out over and over in their 6 meetings, this means they don't have to face the more difficult issue of B2. But that was not the only complaint that those who supported the rule had. A lot of people were concerned that the use of the word willful as an alternative source of finding a sanction really was not a limitation at all, because of the fact that willfulness can be defined by some courts, and has been defined by some courts, to merely mean that the party acted intentionally. And so there were various types of suggestions, for example, that they had to be both a willful and a bad faith action, or that one should rely solely on bad faith. And then, frankly, there was also some rumblings that this first clause about curative measures was unfairly being let loose upon the rule without a requirement of prejudice, much less culpability. And the Sedona Conference, I'm a member of I have been a member of the Sedona Conference Steering Committee for a long time, and I'm a former chair of it. We filed a comment pointing out that the types of things they're talking about in subsection A really are sanctions, and at least in many cases, and that it's an artificial distinction between curative measures and sanctions. I think I'm going to stop there, Mary, because what happened was the Rules Committee, the subcommittee, threw up their hands and said, look, the problem with this is that it's not going to address the two things we want most. One is to reduce overpreservation, in other words, the fear of the unknown that causes people to keep too much information. And second, it's not going to really provide a uniform standard sufficient to reject residential funding out of the Second Circuit. So instead, they turned to what we now have, and if you could turn to the next page. Do you have it
Is
up
the
there?
total, the total rewrite.
Yeah, the total rewrite. Now, this one, I'm just going to walk you through it. I don't pretend to fully understand it. First of all, it applies only to ESI. Second of all, the triggering comment, the triggering prerequisite is exactly the same with the words ESI in place of discoverable information. Namely, if a party failed to preserve electronically stored information that should have been preserved in the anticipation or conduct of litigation. So, at least in theory, if it is shown that the party didn't fail to preserve, namely that they lost information but the information wasn't relevant, or they lost information but they did it at a time before the duty to preserve applied, then this subsection is inapplicable. Okay? But in any event, it is a subsection that authorizes a court to do something in the event that a failure to preserve that should have been preserved has occurred. So then they give 3 subparagraphs. The first 2 subparagraphs appear to deal with measures. The word measures is used. Measures that can be ordered by a court, in one case without showing any prejudice, and in the second case with a showing of prejudice. That appears to be the distinction. So taking the first subparagraph, if a party fails to preserve information that it should have preserved, it can be required with the upper limit of that there should not be any measure greater than that necessary to cure its loss. It can be required to permit additional discovery, to require the party to produce information that would otherwise not be reasonably accessible, or they could be ordered to pay the reasonable expenses caused by the loss, including attorney's fees. It's not clear to me, and it's not clear from the committee notes, at least to me it's not clear, that these are the only measures that could be ordered under that circumstance. But that certainly is what it seems to say. Then, however, if the court also is willing to find that there has been prejudice, then it may issue certain other measures which are not defined, so long as they are not greater than necessary to cure the prejudice. Now, in my view, that second clause opens up the entire spectrum of what we have historically called sanctions of any type. And so Section 3 appears to be a carve-out from Section 2 and perhaps Section 1, namely that unless a court finds that a party acted with the intent to deprive another of the information's use in the litigation, you cannot order a court to presume that the lost information was unfavorable. You cannot instruct a jury that it may or must presume that it was unfavorable, and you cannot dismiss the action or enter a default judgment. Now, that's the way I read it, Mayor. I'm more than willing, and I said I've read all 6 of the subcommittee meetings, and I have, and they talk, and I know the committee note talks as well. They seem to talk about priorities, and you ought to try this one first, and then that one first. But my bottom line on this is that they have given up on the idea of a single uniform sanctions rule. They've given up on the role of prejudice as being an important precondition for sanctions, except where there is an intent to deprive another person of the information's use. And,
yeah, I see your point, because those 2 subsections 2 and 3, it looks as though there would be an ordered sort of a step down or a step up, if you will, as to impact. So if the information is just lost, you're just basically curing that loss regardless of prejudice. And then the next inquiry would be, is there prejudice? And then move to the whether or not there was intent to have prejudice. And then the next one would be, okay, there's an intent to deprive, and then it's not clear to me if there also needs to be prejudice as well, if it's a cumulative step down or step up, if you will, or if it's individual factors.
Well, it's clear. It is not, in fact, clear what the role of prejudice is. But if you look at 3 as an exception, or as a carve-out, or as an additional condition, and not as a self-sufficient, in other words, number 3 does not give all of the factors that are necessary to instruct a jury that it may or may not presume the information. All it really says is, look, if that's where you want to end up, you, the judge, want to end up. If you want to end up with an instruction to the jury that the jury may or must presume. And by the way that's worded, that sounds like both a permissible and a mandatory adverse inference, whereas at one point the committee was trying to focus mainly on the mandatory. But if it really does mean that that's all you have to do, I mean that you have to do that in every case where that is to be employed, that still leaves open, in my mind, the question of whether or not you must also show prejudice. It can be read the way it's written. I believe that to be an important open question which needs to be clarified. Let me put it that way.
Mm-hmm. Mm-hmm.
So one of the things that our listeners, who are now probably as befuddled by this as I am, can help us all would be for them to take a look at this rule and read the committee note. We don't have the committee note here, and it's an extensive, it's a 5-page, single-spaced committee note. Take a look at those 2 items. Again, frankly, the only place you're going to find the full text of the committee note is not in my memorandum, but in the agenda book at the pages that are clearly marked in the index. That's where they are. But you're going to have to read them, and then we're going to have a discussion, a really open public discussion about what this means. And I hope that at Portland, the committee will get into that discussion and will clarify and perhaps make whatever changes are needed. So let's turn in the remaining time to the next slide, if we could, because
sure,
both
the factors, yeah.
Yeah, both in the original and now in the amended proposal of the subcommittee, there is the possibility of including a list of factors. And I have only reproduced in front of you now the recommended revision to the listers of factors. There was one more in the list that was in the original one, which has been dropped. But these are essentially identical to the 4 factors that were listed in the original as well. And as you can see, they are fairly, I was going to say, they're not overly comprehensive. Let's put it that way. The first factor is the extent to which a party was on notice and of the possibility of litigation and that the information will be relevant. That clearly is intended to allude to trigger. That's clearly all that has anything to do with. Secondly, second and third, they talk about the reasonableness and the proportionality of the efforts to preserve. Now, those 2 phrases are lifted right out of Rimkus. Rimkus was the decision written by Judge Lee Rosenthal after Judge Schindlin wrote Pension Committee, and frankly, candidly, in reaction to Pension Committee. So they are endorsing both those principles, but unfortunately, they do not want to. They duck the issue of whether or not one can make decisions about preservation based on proportionality. That's an issue they duck, and when you read the committee notes of the subcommittee meetings, you find out they knew they were ducking it, but they didn't really have an answer for that. They knew they didn't want to face it. And then the 4th factor is whether or not the court turned, whether or not the parties turned to courts to resolve any disputes they had about what they had to do. And you'll notice that in that 4th factor, the D factor, it says whether after commencement of the action the parties timely sought court's guidance. The first draft of the factors in the original proposal did not include that phrase, after commencement of the action, which has to do with the sensitivity that the committee members have towards promulgating rules that apply prior to lawsuits commencement. Without getting into a lot of detail, let's just say that is a real hornet's nest that nobody wants to touch, and so they have avoided it by saying, oh, these factors only apply after the lawsuits begin. Well, I don't believe that. But in any event, it was impossible, and they got beaten up pretty badly by people pointing out that how can you run to a court before the lawsuit begins? Well, there are ways to do it. Rule 27 could have been amended. The Sedona Conference, I recommended it. You know, you could have made court access available, but they chose not to get into that. So many of us objected to the guidance factors being in the rule at all. I had a colloquy with Judge Grimm during the first hearing on this, in which he really nailed me to the wall on it, and I had to say, yeah, I think I really don't have a strong view one way or the other, so I didn't really give him an answer. But the LCJ position is that these things are so misleading and so confusing, they ought not to be in the rule at all, and if they're going to be anywhere, they ought to be in the committee note. The subcommittee appears to have bought that argument, and so what they have done is, when you look at the actual text, they've put these in brackets, and they've asked that the Portland Rules Committee decide, do they belong in the rule, or do they belong in the committee note, or do they not belong there at all? So that's we'll hear about that in Portland, Mary.
Yes. Yeah. So we have some other changes we just want to alert you to. So if we move to the next slide, Tom, we've already covered.
I'll cover them quickly. But do we have any questions that we can cover on these other issues?
Well, one question is, do you see a distinction between the words curative and sanctions?
Wow, that's a great question. The Rules Committee certainly does, and they're ashamed. They don't like the word sanctions because of the effect it has on attorneys, and so they have consciously tried to avoid the use of that word. And in fact, I don't believe you will find that word anywhere in their in the subcommittee's recommended proposal. You know, it was in the first one. They dropped it out. Your question was, do I see a distinction? Not really. I really don't see it as a meaningful distinction. I just don't. I think curative measures are in the eye of the beholder. There are lots of things a judge can do to cure problems that it sees. Rule 16 gives them a lot of authority. Rule 26 gives them authority. We're talking here about what happens when a party has lost information that should have been preserved. I regard that as a sanction-based issue, and I wish they would stick with sanctions. So that's my view.
And then the other question is, in both the proposed and the published, both of these things, we're talking about the failure to preserve as opposed to the failure to produce, which is what's in the current existing rule. Do you see a distinction there?
It goes back to this sensitivity over pre-litigation preservation issues. The 2006 committee and the original committee here had different views on that. The 2006 folks were not willing to admit that something was being done about stuff that was prior to commencement, so they used failure to provide. In other words, they were saying it doesn't really matter why you didn't keep it. If you don't provide it, we're going to sanction you for it. Now they're being a little bit more honest, a little bit more upfront, that their focus really is on the failure to preserve. That provides, I think that's a better way of articulating it, and I'm pleased to see that change.
Okay, and then the other question is looking at the guidance factors 4C, where it says to any anticipated or ongoing litigation. Do you see that as something different than the current matter that might give rise to using that provision?
I'm not sure I understand your question. The phrase is intended to cover both pre-commencement failures as well as post-commencement failures.
Right, but does it include other litigation?
You're asking a different.
I'm asking a different question. Yeah.
Yeah, you are. The committee seems to be shifting its views on that. I say the committee, and I'm really talking about the subcommittee. The subcommittee was aware of the fact that they had testimony, particularly at Dallas, to the effect that, look, just because it might be applicable to some other kinds of litigation doesn't mean that we've done anything wrong by not preserving it. And so they stuck the word "the" in front of litigation at some point. In 37E3, they stuck the word "the" in front of the word litigation, I think in response to that. Here, as you correctly point out, they did not. And that is an error on their part. They should have stuck it in there. I think they intended to stick it in there, but they just forgot to do it.
Okay.
Or not. Maybe they do mean to have it apply to any litigation, whether it's related to the one that that the guy had in mind or not. There are some cases that hold that, as you well know.
Yes. Yes. Yeah. And so, no, thank you. So we have a couple more minutes before I think you need to move to another meeting, Tom. So if I just sort of bounce through the other changes. We already talked about the presumptive limits being out, and then we have in the scheduling order and in the meet and confer. We also have a change in timing for it to be issued 30 days earlier. Although the way I read it, Tom, is that for more complex litigation. And by agreement of the parties, they can push that out a little bit if they need to. So it's not a hard limit.
Correct. Absolutely.
There's also preservation is called out as something that can be put into the scheduling order.
And I said that one. I had originally recommended that at the Duke conference. And the reason they didn't do that in 2006 was they didn't want to encourage overuse of preservation orders. That was really what they were trying to get at. And there is a comment in the committee notes, when you read them carefully, to the effect they think that this now will, in fact, lead to more preservation orders, which is certainly not what anybody intended. but it, if it does, it does.
Right. Except that if you violate an order, it's a little more serious, I think. So the other changes, Tom, what do you think about the ability to sort of not have the discovery moratorium, to be able to make a request for production before the meet and confer? Do you think that's going to help narrow the issues, or do you think it's just going to start the clock on production sooner?
Well, no, it doesn't start the clock. The clock doesn't start until afterwards. Early delivery does not start the clock.
The clock starts at the first meet and confer, though, doesn't it?
It does, but let's say you deliver it 3 weeks ahead of the meet and confer. It doesn't start 3 weeks earlier than that.
Right.
Okay. The earliest the clock starts would be at the meet and confer. Mary, because I don't practice any longer, I have to defer to those who do practice on a day-to-day basis. I hear a lot of negative comments about drive-by 26F conferences, and as I teach a course on it, and I've had magistrate judges come in and they tell my class that nobody pays any attention to it, and that's kind of discouraging. At least in theory, it should enhance the ability to have a meaningful discussion of preservation and other issues at the meet and confer. I would like to think it would enhance it. Mm-hmm. So I support it. So.
And then the other rule, we just want to make a note that Federal Rule of Evidence 502, which, every conference I go to, the judges will ask for a show of hands of how many people are using it, and they're always appalled at the lack of hands. So it's being called out in the for the meet and confer, the discovery plans, and scheduling orders as well. So it'll probably be used more often. So Tom, we're on the slide with suggestions. Do you have some suggestions for people before the Portland conference?
Having just gone through these subcommittee meeting minutes, and if you have time to read some of these suckers, I think you find them really fascinating. But they are somewhat confusing, I have to confess.
Well, and my sense is that with proportionality and with preservation, the more of a focus on preservation, having some good information governance with the proportionality, having some metrics. I think that some of what I read in the notes, gave a sense that the more intuitive, anecdotal was okay, but I'm seeing more and more numbers and hard data requests in the notes and in the cases. So metrics, I think, are knowing what your case is worth right at the beginning is going to be very, very important.
That is the downside to moving the proportionality factors up front. If you have to make a case for why a particular type of discovery is disproportionate, you're going to have a better way of explaining it than just saying it. You're really going to have to say, well, this involves looking at 640 custodians, and we now have 900 databases that we'll have to check. You need to be prepared to do that. And so the plus is that you get it aired earlier, but the minus is you're going to have to justify. And I would say, to the credit of the requesting party lobby, they've made it very clear that they're going to be watching how courts apply these new rules, and they're going to raise hell if it turns out that judges just without proof of disproportionality just start saying it. So it's time for people to be prepared to explain the costs of a disproportionate request.
Yeah, well, I think it's fair to say that over the next few weeks there's going to be quite a bit of discussion. So definitely stay tuned. I know Bob Owen is going to. I think he's at the virtual corporate counsel event. There was something scheduled for a few days from now, and he'll be discussing this, I think, publicly. And I'm sure others will as well. I don't know of anything else that's scheduled prior to Portland, but certainly the ACIDS conference, where Tom will be on the committee with a member of the Rules Committee, and it's a couple of judges that you have on your panel. If I'm not mistaken.
Well, John Barquette, who's on that panel, is actually a member of the subcommittee that came up with this Rule 37E provision. So John will be very helpful.
All right. So anybody who needs a copy of Tom's paper, you can send an email to annalore.vanderlint at xylab.com. We'll be happy to send you a copy. And on behalf of Xylab, I want to thank Tom for not only agreeing to do this webinar, but also taking it on to wade through the 580 pages so that what he was presenting was totally fresh and relevant, and not something that he had prepared before, and wouldn't have had enough time to go through 580 pages. He as he always does, prioritized the rules. Tom, I've known you as a steward of the rules for as long as I've known you, and I just want to thank you for all your good work on this, Sedona and all of it.
Thanks, Mary. You're most kind.
And this will end our webcast, and I thank all of you for your kind attention on this beautiful Tuesday morning. Thank you.